I'm not very happy that he didn't show up on December 4th under the circumstances. I can let that go. Sir, no violations of law.
Okay.
This is where the case shifts from a simple probation violation into something way more serious. The judge isn't just looking at missed requirements anymore. He's now being pulled into allegations that could completely change the outcome of this entire hearing.
Fernandez, Derek Tanbelda Fernandez, 25W707530. Your name?
Morning, Your Honor. Quick percent, you hear me of my client. Stands to my left, sir. Can you say change for the record?
Derek Fernandez.
So he's charged with failing to attend the domestic violence program, the one-day program on October 7 of 25. And he's also charged with failing to provide proof of completing, it looks like 31 hours of community service by October 20 of 25. How is he going to proceed?
Your Honor, in this circumstance, you understand that he did not do it within the time division, so he would not be asking for a contested violation.
So he's going to plead guilty?
Yes, Your Honor.
Is that what you want to do, sir?
Yes, Your Honor.
If you plead guilty here, this would be 3 prior technical violations, or 3 technical violations. Your 7694A status could be revoked, conviction entered, and since this is a domestic violence charge, you could receive 93 days on this. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice of rights form here today? Or not?
Notice how the courtroom language here is very deliberate. The judge is making sure the defendant fully understands his rights before pleading guilty, because once that plea is entered, there's no going back. This is the legal point of no return.
Judge, if he hadn't done that earlier, we can go through that.
You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. If you plead guilty, you're giving up all the rights on the advice of rights. You're giving up your contested right to a hearing, your right to question their witnesses, your right to bring in your own witnesses, your right to testify or remain silent, your right to bring in your own witnesses. If you plead guilty, you're giving up all those rights. We're not going to have a contested hearing. Do you understand that?
Yes.
As to count 1, for the charge you failed to attend the domestic violence program, how do you plead?
Guilty, Your
You
Honor.
failed to attend the one-day domestic violence program on October 7 of 25.
Guilty.
Did you fail to attend that program on October 7 of 25?
Yes.
Is the count 2 that you failed to provide proof of completing 31 hours of community service by October 20 of 25? How do you plead?
Guilty.
You failed to do that by that date?
Yes.
Anybody force you to plead guilty?
No.
Accept your pleas.
I have that pleas were taken on this back on December 4th. He pled guilty to count 1 and we dismissed count 2. He did provide proof of completing community service and it was done prior to the due date.
Hang on a second. Oh, I see. Yeah, he didn't show up for sentence.
Yeah, there was a situation. So you had ordered him to come back for a sentencing date on January 6th. You ordered him to get a job and provide proof of mental health treatment. He never showed up and then he went for warrant status.
Why not?
He was hospitalized, Your Honor, from January 13th to January 29th.
Okay, well, why didn't he come in this last month?
I spoke with him, Judge. I think that he had some trepidation, but he did come in on his own volition today.
This is a critical turning point. Missing a sentencing date after already pleading guilty raises immediate red flags for any judge. In probation law, failure to appear often signals deeper compliance issues beyond just paperwork.
We have the health records,
So I did get proof from Team Wellness that he is back engaged in treatment.
but he was in treatment.
I didn't have proof that he was in treatment before. My concern is that between the last time he was seen with Luke and now, is currently under investigation with Brownstown for terroristic threats. So there's been a lot that's been going on between when he was last seen and now turning himself on his warrant. So things are still pending. Charges haven't been placed yet. They're still searching and investigating that. Last time they talked to Brownstown, which was about a week or 2 ago, but I'm concerned there's some deeper things that are going on here with Derek.
And you dismissed the failure to complete the 31.
Yeah, so he completed
You
it.
dismissed that on December 4th.
He completed them at ChristNet. ChristNet emailed me and said it was their fault. They thought they sent it over and they forgot to. He did complete them in time and they were supposed to send it over, but they didn't.
Is somebody here with you?
Yes, my dad is here.
These are extremely serious allegations being mentioned: terroristic threats, federal agencies, and explosives-related language. Even without charges, courts treat this kind of information as high risk because it directly impacts public safety assessment.
Terroristic threats to who?
He, if you want me to read, this is what I received from the police. He was posting threats on X, which is now was Twitter, and was tagging federal law enforcement agencies. The threats included blowing up ICE agents in neighborhoods, sneaking bombs onto planes, and possessing child pornography on his phone. Officers and TSA agents went to his home on January 29th. They ended up committing him to the hospital because he fought with police. They were then executing search warrants at that time, Your Honor.
He has not been charged.
He's not been charged as of yet. I emailed them back about 2 weeks ago. The officer stated that they're still under investigation at this time.
I've tried to be understanding with you, sir, in the history that you have. I'm really trying to be understanding, but and I don't want you to talk about that case. You've not been convicted. You've not been charged. In all honesty, it's inappropriate for me to take that into consideration as of this point. Do we have the proof? I'm sorry. I think you said you have proof that he's attending treatment again.
Yes, I just received a letter from his therapist. I believe it's.
We don't have proof that he did the inpatient. Correct? He was inpatient, right?
Yes, he was hospitalized inpatient from the 13th to the 29th.
I don't have proof of that. All I know is that at the end of January, he was committed for sure based on what I received from the police. But I don't know for how long he was there. I don't have proof that he was committed that day.
Sometimes judges. What is that? Is this going up there? Or is that trains beating each other? I don't know how I want to proceed here. I've got to think it through. I've accomplished nothing here today. All I did was reiterate that a plea was taken back on December 4th. I'm not very happy that he didn't show up on December 4th under the circumstances. I can let that go. Sir, no violations of law.
Okay.
No violations of law.
Yeah, yes, thank you.
Can't violate laws. I'm going to assume you didn't do this, and I'm talking about what she's saying. Threats. Very bad. Very, very, very bad. My inclination right now is to revoke his domestic violence 7694A status, enter the conviction. But I don't need to make a big rush into this. I'm going to adjourn the sentencing again for a couple of weeks. Let's give me a date, Heather. The end of March. No violations of law, sir. Do we understand that?
Yes, I understand.
To March 31st at 8:45.
Again, I cannot reiterate enough how inappropriate it would be to sentence him based on a violation of law when he hasn't even been charged with it. And that's what's kind of throwing me here, but it scares the devil out of me when I hear these kinds of things. We don't get to threaten people, and nobody should be able to do that. And that's that. I'll give you that date. Go down, get your notice. No violations of law is a condition of your bond. Do you understand that, sir?
Yes, I understand.
I want to make sure. Do you understand what I'm telling you?
I understand, no violation, or no.
And you keep going to mental health treatment. You understand that?
I understand.
Here you can see judicial restraint in action. Even though the judge is clearly disturbed by the allegations, he is legally required to avoid sentencing based on uncharged conduct. This is a key principle of due process.
All right. Your name?
John Caruso?
Did they offer you anything on this, or you just didn't want to do this?
Well, no, they did offer me something. I guess I'm just was trying to plead my case. I was literally 2 blocks away from my house. I'm new to Michigan. I used to live in Michigan. Wasn't aware that there was a law against answering the phone, but I don't normally do that. I normally do hands-free. I was telling the officer I was waiting on an important call. I was at the corner of Grain and West because I purchased an electric bike from Petrie's on Allen Road, which is now closed. And I got a notice that there was a recall due to a defective bolt on the back tire. So I was waiting.
Okay, so let me tell you, did they offer you impeding traffic?
Yes.
I'm not going to lie to you. I'm not a fan of these using mobile device, but you're better off. You don't want this on your record. If they're going to offer you a plea to impeding, you can't.
Okay.
I'm just telling you. I'm not. I think you might want to go back into a breakout room and talk to them about taking that if you want. I mean, I can't. This is not an intent crime. It's a civil infraction. There's no judge in the world that's going to throw this out because you didn't know about it. I'm just telling you.
Okay. I just thought the fact that I was like 2 blocks from my house when the phone rang, I answered it. But I understand, Your Honor. So
you want to talk to him again about giving the impeding? You don't want this nonsense on your record.
Well, that was I was going to agree to that. I guess my big concern is I know there's no points. I'm fine with that. I just didn't know if it was going to affect my insurance rate, which I was
Impeding will not affect your insurance rate. This being on your record, this operating a mobile device, using a mobile device while operating a motor vehicle does not look good. I'm not going to lie. And I got a pet peeve about it because I see people doing that all the time and they're swerving all over like they're drunk. I'm not sure which is worse.
Right. No,
if you want me to, I'll send you back to them. You can tell them you want impeding if that's what you want to do, where you can have a hearing. But
no, I'll do the impeding. I'm out of town. I'll be back for a couple days on
well, that's all right. Let me send you back to them by Zoom. John, take this back over to Trenton, will you please?
Okay.
Just bear with us, and she'll put you back into she'll put you back in a breakout room with Trenton, okay?
Okay, thank you, Your Honor.
No problem. And then we'll take care of it. Cheryl Noble, John Bruno Caruso, 260-647-7750. Sergeant Neese.
Yes, Your Honor.
Name?
Sergeant Neese, Trenton Police Department.
Mr. Caruso, your appearance?
I'm here.
I need your name again.
John Caruso.
All right. So, Sergeant, I think he wants to take the impeding, and he said that you offered that. Is that true?
I did, and he has indicated that to me in this meeting, Your Honor, the second meeting.
Okay. So, is that what you want to do?
That's fine with me, Judge.
To the charge of impeding traffic, Mr. Caruso, responsible or not responsible?
Responsible.
All right. You'll probably not talk to me again, even though I've known you for years, because I just don't like these. $200. I'll give you time to pay if you need it.
Well, Your Honor, he had lowered it to, I thought, at 155.
No. You guys got to quit. If you told him that, Sergeant, you got to not be telling people what I'm going to fine him. I got my own little calculations going on in here. I can't just charge 155. And somebody else was telling somebody 135 today. I just don't do that. I'm sorry.
Well, I certainly didn't tell anybody 135, and I was unaware of anything
I'm
beyond
not saying it was
155.
you. I don't know what department rep it was. But I can cut these down, but I can't do better than this. This is what I've been charging everybody. So I can give you a week or so to pay if you need it, but that's the best I can do.
So $200.
Yeah, I can give you till March 10th. You want March 10th?
Yes.
Okay, I'll give you.
Wait a minute. I'm coming back on Thursday. What's Thursday?
Tomorrow?
No, Thursday. Okay, yeah, I can pay it on Friday, so I'm good.
And you can go right online too on 33court.com with your case number if you'd like. And Sergeant, I wasn't casting aspersions. I'm just telling you, I sometimes hear, and I don't know who they're talking about. The officer told me that they should not be doing that back there. I'm not saying it's you, but they should not be doing that back there. That's all. Thank you.
Thank you,
Have a
Judge.
good day.
You too.
Thanks, Mr. Caruso.
Thank you.
Pat.
This is actually a strategic delay by the court. Instead of revoking probation immediately, the judge is essentially giving one final opportunity, but also placing the defendant under strict conditions. One mistake now could trigger full revocation.